Okay, I suggest we get started. Hello everyone, and welcome to 4IP Council's webinar entitled FRAND Licensing Levels under EU Law, Components or End Device. My name is Axel Frazzini. I'm the Managing Director of 4IP Council. As you may already know, 4IP Council is a not-for-profit research council developing high-quality academic insight and empirical evidence on topics related to intellectual property and innovation. On 4IP Council's website, we offer an extensive body of research addressing current intellectual property and innovation themes. You will find a summary of the papers today's presenters have developed on FRAND licensing levels and many more reports and publications. A popular resource we offer is a library of case summaries covering national court decisions following the CJEU ruling on Huawei versus ETSI. Please click Stay Informed on the right side of our homepage to be informed of new cases, research, and future webinars. We are also committed to encouraging innovative SMEs to use IP to grow their businesses, and we provide a range of resources to help them achieve this end. We will upload this webinar and the slides free of charge following the presentation. Please remember to use the Q&A tool to post your questions that you may find at the bottom of your screen. Today, we have three presenters joining you from their homes. Please allow me to briefly introduce you to our great speakers. Dr. Nicolas Petit holds the chair in competition law at the European University Institute and the Robert Schuman Center for Advanced Studies. Nicolas Petit is also invited professor at the College of Europe in Bruges and a full professor at the Law School of the University of Liege. Dr. Igor Nikolic is a senior fellow at UCL Center for Law, Economics and Society, and a fellow at European University Institute. And Dr. Jean-Sébastien Borghetti has been a professor at Paris II Panthéon-Assas, France's first law faculty since 2009. He specializes in contract and tort law in a comparative perspective and has taught in several countries, including the US. He also practices as a counsel and arbitrator. Without further delay, I will give the floor to Professor Nicolas Petit. Nicolas, the floor is yours.
Thank you very much, Axel, and good afternoon to everyone. It's a pleasure to be here to talk about our paper. So without further ado, let me get started. So, you know, as most of the audience will know, a lot of electronic devices communicate thanks to interoperability specifications developed and improved by standard setting organizations, SSOs, we call them. The standards they develop, they come in generations known under acronyms like 3G, LTE, 4G, Wi-Fi, 5G, and so on. Now, the standards are often covered by dozens, if not hundreds of patents, and some of these patents are called SEPs or standard essential patents to denote the idea that their use is necessary in order to make products that comply with the formal specifications set by the SSOs. Now, a lot of SSOs have intellectual property policies that provide that the SSO will only incorporate patented technology into standard specifications if the patent holder commits itself to making licenses available to implementers on FRAND terms. And in past years, there's been a lot of disagreements between owners of SEPs and unlicensed implementers over the degree of obligation created by a voluntary commitment to license on FRAND terms previously taken by the patent owner before or within the SSO. So one question, so next slide, please. One question that has created increased discussion in the industry is the question at which points to license in the production chain. And this is important in the IoT, Internet of Things context, because we anticipate that a very large number of devices and components will read on SEPs. Next slide, please. So on the one hand, current industry practice suggests that SEP owners are free or feel free to choose at which level of the production chain they can license, and they should license. And usually they have done that at the end product device level. This norm, if we can say, is known as the access to all regime. So you would have owners of SEPs licensing handset manufacturers in mobile telecommunications, access to all. But at the same time, another idea that is being pushed in the discussion is that it would be interesting and more optimal from a welfare standpoint to force SEP owners to license at all levels of the value chain to any company that requests a license, including component manufacturers. And this system is known in policy circles as the license to all regime, LTA. So in essence, the underlying issue is the following. Should SEP owners maintain the practice of licensing their patents at the end device level, or should they license at the component level in an IoT context? Right? This is sort of practical question, practical policy question that is today being discussed. Next. So with my colleagues, Igor and Jean-Sébastien, we certainly consider that the should question, should patent owners be free to license at the level they want, or should they license to all and any firm in the industry production chain? The should question is important from a policy standpoint, and all the more so as the European Commission and industry groups like Senelec and others are taking distinct positions on ATA versus LTA. Next slide. But one preliminary question we believe is before the should question is a does question. It's a legal question. Next slide. So the question is, does European Union or national law related to FRAND commitments imply a preference for ATA versus LTA? Or to put it differently and maybe more generally, do EU and national laws leave licensing freedom to SEP owners, ATA, or do these bodies of law constrain their licensing level choices by forcing them to license at all and every level in the supply chain? Now, as far as we know, there's been no comprehensive survey of the requirements set by the law on owners of FRAND commitments in relation to the licensing levels that they practice. Often scholars have sort of, I think, assumed that the law was clear, and that's a very optimistic way to see the law, to see and read the law. Or most of the discussion has focused on normative discussions, where our policy discussions on what's more optimal from one particular standpoint. And so in the paper, we've sort of decided to strain as much as possible from the normative discussion and try to adopt what lawyers, academic lawyers would call a doctrinal analysis, to look at what the law says on that, if it says anything. And so we cover 4 areas. We cover general principles of EU law, we cover patent law, we cover contract law, and we cover competition law. So I will focus on general principles of EU law, and my colleagues Igor and Jean-Sébastien will follow with the other domain areas that are discussed in the paper. Next slide. So to start with, EU constitutional law, there are two principles that might be relevant to knowing whether a FRAND commitment gives rise to an LTA obligation, a license to all obligation. The first principle is the principle of legitimate expectations. The principle of legitimate expectations is a principle that limits the discretion of public administrations. It limits their freedom to make policy choices that contradict previous initial assurances or statements made before the citizenry. So for instance, if the administration says that traffic offenses will be charged on the owner of the vehicle, they cannot decide to change course without announcing it and charge users of the vehicle. They have to make an explicit choice and notice that to drivers and owners. So the reason why this legitimate expectations principle might be relevant in a FRAND context is that the Court of Justice of the European Union in the case Huawei versus ZTE said that a refusal to license can constitute an abuse of a dominant position, more on that later, because the FRAND term given to the SSO creates legitimate expectations on the part of third parties. And so to put that a little differently, a breach of the legitimate expectations principle could provide the legal reasoning underpinning claims of abuse of dominance seeking to force an LTA licensing model. Now, is this realistic to consider that the legitimate expectations principle might constitute the rationale behind abuse of dominance findings in FRAND licensing disputes? Now, we certainly think, I mean, following careful analysis, that this is not really what the law seems to say. So to start, a careful reading of the Huawei versus ZTE judgments suggests that this notion of legitimate expectations has to be assessed on a case-by-case basis. The court says that legitimate expectations arise only in accordance with the undertaking given to the standardization body. In other words, a FRAND commitment given under the IEEE policy, which is quite prescriptive on licensing models, will not give rise to the same degree of obligation than a FRAND commitment given to the given under the ETSI policy, which is less prescriptive in terms of the licensing conditions attached potentially to a FRAND commitment. So that's one thing. There's no one-size-fits-all licensing regime arising from the principle of legitimate expectation. The second thing is that the principle of legitimate expectations in the case law of the Court of Justice is not the source of an unqualified obligation on an organization, be it a public administration of a private or a private company. The principle of legitimate expectations requires proof that the organization, the administration here, you know, in my example, the police authority has given precise and specific assurances. And in the context of FRAND, it's pretty unclear that, you know, a FRAND commitment conveys anything precise or specific in terms of where, how, and other details about the future licensing transactions, right? So that's our assessment. We believe that there's, you know, not too much to be read in that reference to legitimate expectations, and if anything has to be read, it's pretty abstract and vague, and certainly not of the kind of precision that you would require to mandate LTA pursuant to European law. Next slide, please. So an alternative source of LTA obligation on SEP holders could be explored in the profuse case law on non-discrimination. And so, you know, you will know that in EU law, non-discrimination is recognized by various provisions. And, you know, one potential idea could be that unlicensed implementers would complain that a SEP owner discriminates by refusing to license to them. And in another industry, the same SEP owner gives license to component manufacturers, right? So you can have this situation in which component manufacturers would feel discriminated because in other industries, so in automobile, for instance, the SEP owner would license at the end user level, but in the aircraft industry, it would license at the component level. So would that give rise to a discrimination liable to an infringement of European law on non-discrimination? So we believe that there are general reasons and specific reasons that counsel against the application of the non-discrimination case law or equal treatment case law of the Court of Justice. The general reasons are essentially that the Court of Justice has been very cautious not to transpose the non-discrimination obligation to horizontal situations between private parties. It has only done that in very limited circumstances. It's generally applicable in disputes between state entities and private parties. It applies in disputes between horizontal parties, but in very specific contexts in which you have certain types of other rights and considerations which are not present in FRAND licensing context. We explain that in the paper. The specific reason is that the Court of Justice, again, in Huawei versus ZTE, was pretty clear that the problems of discrimination that you might contemplate under EU law are problems, there are problems when the relationship are competitive relationships. So at paragraph 64, the court said that the duty of equal treatment pursuant to the ND prong of FRAND commitment only arises in the relationship between the licensee and its competitors, right? So which means that there would be no possible finding of discrimination if component manufacturers in distinct industries, namely not competitors because they're not in the same industry, would be in one case refuse the license, in the other case given a license. All right, so that's all for me. Now I hand over to Igor.
Thank you, Nicolas. So next slide, please. Next slide. This is it. So thank you. The next area that we covered is patent law. So we try to see, well, what does patent law say about where to license in the production chain? And it's interesting first to recollect just the basic principles of patent law. So generally, to find out whether a product is infringing a patent, we need to read the claims of the patent. So only if a product falls within the scope of the claims of the patent, we can say that the product is infringing the patent. And generally, by patent law, a patent owner is free to decide what does he want to do with the invention. He may decide whether to license or not. And if he decides to license, he is generally free to set the terms of the license. Or if he doesn't want to license, he can actively pursue injunctions, try to exclude others from using the invention, or it may just simply consent to infringement without enforcing the rights, in which way the patent owner is, we can say that he is kind of giving away invention for free. Now, when we have a FRAND commitment, these basic principles changes a bit. So first, when you have FRAND, the patent owner cannot reserve the implementation of the patent only for himself. He must make licenses available to the users of a standard. And also, he is bound by giving licenses on fair and reasonable non-discriminatory terms. So his licensing is constrained. Now, next slide, please. Now, unless specifically provided by the FRAND commitment, the question where to license in the production chain is regulated by the patent law. And we will see in the next section on contract law whether the text of the FRAND commitment provides explicitly where to license. But if it doesn't, then we revert back to the principles of patent law. And as I mentioned, only those products that infringe the claims of the patent would need to take a license, and then only if the patent holder so requires. So the first step in the analysis on the patent law is to look at the claims of the patent. So if they claim only components, then the natural choice would be to conclude licensing agreements with component manufacturers. But if they have broader claims, if they read on downstream devices, on networks, that can complicate the picture. So next. So we looked at what do generally SEPs claim. And we looked at the study from Putnam and Williams, which analyzed the claims of Ericsson's SEP portfolio. And they found an interesting picture and found that actually the SEPs are not confined to a single component. They found various components alone, various components in combination, complete handsets, and also handsets in network. So the takeaway from their study is that none of the SEPs claimed only one component or only the chip, and about 2/3 of SEPs claimed some aspects of user network, that is downstream products. Now, we also looked at some SEPs that were found to be valid and infringed in the litigation. And we also came to the same conclusion. Well, in the litigation, the patents related again to the whole networks or complete handsets in networks. So for example, in Unwarranted Planet versus Huawei in the UK, 2 patents that were found to be valid and infringed. They related to a method and arrangement in a wireless communication network, and another patent related to a method for improving handover between mobile communication systems. So we can see from these 2 cases that those patents claimed much larger than a single component. Next slide, please. So the takeaway from this brief study is that in a complex standards like 3G, 4G, 5G, patents are complex and they cannot be subsumed to a single component. Now this has a consequence for the licensing and which level to license. As we can see, if products do not infringe, if components are not claimed, then component manufacturers would not need a license. And another result is that there are those SEPs that do claim components, and component manufacturers could request a license for those subset of SEPs from the portfolio that read on a component. But from patent law, they wouldn't have an active right to force the owner to license, unless they would have maybe contractual right, but not right from the patent law. Next slide, please. Also interesting from a patent law perspective is the doctrine of patent exhaustion, which also operates from behind and regulates in which production chain level the production chain to license. So the doctrine of patent exhaustion means that the first authorized sale of a patented item terminates all patent rights in that item, or in translation, you can license your patent only once per production chain. So you can license your patent either on component level if it reads on component level, or either on end device level if it reads on end device level. So this again has a consequence to choose where to license in the production chain. So as we said, if we would be licensing only to component manufacturers, only those SEPs that read to components, that would not exhaust the majority of other patents that read on downstream devices. And then downstream producers would also need a license. So that would create a requirement to license at multiple levels of the production chain. On the other hand, if we adopt a policy of licensing, for example, on a downstream level, that the patent of doctrine of patent exhaustion would exhaust patents on that level. It would also protect further downstream producers like networks, but also component manufacturers who are selling to the licensed and device manufacturers would be indirectly protected by an indirect license, because they would be selling to licensed downstream producers, and they would be covered, and it would be very unlikely we would see later from a computational perspective that any SEP owner would successfully claim injunction against them. So that would be me, and next is contract law by Jean-Sébastien.
Hello, so I'm taking over and addressing the contractual issue. So it's widely acknowledged that FRAND commitments are of contractual nature. However, it's difficult to speak of FRAND commitments generally because each SSO actually has its own FRAND commitment, i.e. requires from people holding SEPs, standard essential patents, to make the commitment to license on fair, reasonable, and non-discriminatory terms. And these various commitments may be different, and they may vary. So you cannot talk of, from the perspective of contract law, you cannot talk of FRAND commitments generally, and you've got to look at each specific commitment that is at each commitment of the commitment of each standard setting organization. So in our paper, we focus on the FRAND commitment of the ETSI, which is one of the most important standard setting organizations, but we also take a short look at the commitments of other SSOs. So first of all, let's turn to the ETSI FRAND commitment. Next slide, please. So as probably most people know, ETSI is a European standard setting organization which creates standards applicable to the telecommunications industry. And this organization is headquartered in France, and its bylaws are governed by French law. So there has been some debate. So the consequence of this is that the ETSI FRAND commitment is governed by French law, and this is something which is undisputed. Then there has been some debate as to how the ETSI FRAND commitment operates. So to make a long story short, it's now generally accepted that the ETSI FRAND commitment is what we call in French law a stipulation pour autrui. So it basically creates a contractual right for potential licensees to get a license. So what exactly is this right, and what exactly is the obligation of SEP holders under the ETSI FRAND commitment? Well, SEP holders are bound to negotiate in good faith with potential licensees towards the conclusion of a license on FRAND terms. Next slide, please. And then we come to the main question for our paper, which is who are the beneficiaries of the ETSI FRAND commitment? So to answer this question, you might want to turn to the non-discrimination prong of the FRAND commitment, since FRAND, as we said, means fair, reasonable, and non-discriminatory. And so we might think that non-discriminatory means that any potential licensee, that is, anybody along the production chain, should be entitled to a license. However, the non-discrimination requirement under French law, and I think generally, only means that you're not allowed to treat differently persons who are in the same situation. So non-discrimination can only apply to persons in the same situation. And as regards the production chain, then it's quite clear that companies which are at different levels of the production chain are not in the same situation. So you cannot rely on the non-discrimination prong of the FRAND commitment to endorse an LTA approach under the ETSI FRAND commitment. So let us now turn to the wording of that FRAND commitment. Next slide, please. So if we want to know who are the beneficiaries of the ETSI FRAND commitment, we should, of course, turn to the text, to the terms of that commitment. And this commitment is actually based on clause 6.1 of the ETSI IPR policy, which I'm not going to read here because it's quite long. But what this clause says is that SEP holders must be prepared to grant licenses on FRAND terms to basically manufacturers of equipment. So the question becomes, what does equipment mean under the ETSI IPR policy? And this word is actually ambiguous. And when you have an ambiguous term in a contract under French law, then of course this term must be interpreted. So that brings us to the issue of the interpretation of clause 6.1 of the ETSI IPR policy. Next slide, please. So under French law, the basic rule for interpretation is that a contract or a contractual provision, such as the ETSI bylaws, should be interpreted in accordance with the party's intention when entering the contract. But then there are cases where this intention cannot be ascertained. And in those cases, then you should turn to the meaning which a reasonable person would give to the disputed terms. So you've got one main rule and a subsidiary rule. So the main rule is to look at the intention of the parties. But then, of course, it's quite difficult to determine what the intention of the parties, that is, of all the ETSI members, was when the ETSI IPR policy was adopted. We actually have some testimonies about what the intentions might have been, but the problem is that these testimonies are actually contradictory. So it's quite well known that two former senior officials of the ETSI, namely Mr. Rosenborg and Dr. Huber, have given their own perception of those intentions, and those testimonies actually conflict and kind of cancel each other. What we can say, however, is that recently, or over the last years, ETSI obviously resisted proposals to modify its IPR policy in order to explicitly endorse the LTA approach. So this refusal to explicitly endorse the LTA approach suggests that the initial intention of the ETSI when adopting its IPR policy was not to implement that LTA approach. But nevertheless, that's not totally clear. So we must turn to the other interpretation method, and so look at how a reasonable person would interpret or would have interpreted clause 6.1 of the ETSI IPR policy at the time when this policy was adopted. And so it seems that the common practice at the time when the policy was adopted in the telecom industry was to grant licenses at the end user level and not at component level. And so a reasonable person familiar with the industry at the time when the policy was adopted would have considered that the policy actually endorsed that normal course of business, we could say. And this is actually confirmed by the fact that the IPR policy uses the word device and avoids words such as element, component, part, or unit. Next slide, please. So our conclusion concerning the ETSI FRAND commitment is that this commitment actually only benefits manufacturers of end-user devices, and it does not benefit all operators in the production chain, including component makers. This means, in other words, that SEP owners under the ETSI FRAND commitment are bound to negotiate in good faith towards a license on FRAND terms with manufacturers of end-user devices, but they are not bound to negotiate with other companies along the production chain. Of course, they are allowed to negotiate with implementers at other levels of the production chain, but they are not bound to do so under the ETSI IPR policy. Next slide. So that was for the ETSI, but then of course you've got many other SSOs. And here it's, well, we didn't have time in our paper to look in detail at all the other SSOs and their IPR policies. But what we can say very shortly is that they basically fall into two categories. The first category is actually quite small and boils down to the IEEE, which is an American Standard Association, which explicitly endorsed the LTA approach recently. So in that case, it's clear that the FRAND commitment leads to an obligation to license at any level of the production chain. As far as the other SSOs are concerned, as far as we know, there is no endorsement, official endorsement of the LTA approach. And some IPR policies of other SSOs speak, for example, of applicants. So it raises the question, who are those applicants? Are they just end device manufacturers, or are they any manufacturers along the production chain? Our conclusion is that when the wording of the ETSI policy, of the FRAND commitments is ambiguous, it would be wrong to impose an LTA obligation for basically 3 reasons. The first reason is obviously that the standard setting organization are free to change their policy to explicitly endorse the LTA approach if they wish to do so. The second reason is that the wide industry practice seems to be licensing at the end user device level. And so presumably what most standard setting organizations intended to do was just to confirm this practice. And the third reason, which has been mentioned about patent law, is that many standard essential patents have wide claims that actually cannot be implemented in a single chip. So licensing at chip level might not make sense. I'm now handing back the word to Igor for competition law.
Thank you. So the final area that we looked at is competition laws, and to see whether a competition law may provide a legal basis to impose an obligation to license to all. Or in other words, can we say that the refusal by the SEP owner to license to component manufacturers may be an abuse of dominant position? Well, we have already formulated legal test in the EU competition law when the refusal to license can be an abuse of dominant position, and that is only in exceptional circumstances. And it follows from the case law of the European Court of Justice that these 3 criteria that you can see on the screen must be cumulatively fulfilled. And if you look at it, we think that these criteria are not fulfilled, but in the case when the SEP owner adopts a policy of licensing SEPs only on the end device level. This is because we believe that the first criteria, that refusal to license SEPs on a component level, is not indispensable for component manufacturers to be on the market. And next slide, please. This is because it's very important to make a distinction that refusal to license does not mean automatically refusal of access to standard. Or in other words, not having a license does not automatically mean exclusion from the market. This is very important to make this distinction because it seems to be often confused. Because patents are intangible goods, and the only way that a patent owner can exclude infringer from the market is if he goes to court, proves the infringement and validity of a patent, and gets an injunction. Now, all those steps don't follow automatically. And as we saw from the patent law, from various reasons, patent owner may decide not to sue. So for example, if the patent owner adopts a policy of licensing only at end device level, he will then not sue component manufacturers, and therefore there is no exclusion from the market. SEP owner may also not have a licensing program for various reasons. He may decide not to license, keep patents for defensive purposes, in which case, again, there is no license, but also there is no exclusion from the market. And we can see from the general practice in the industry that also licensing happens after products appear on the market. So this is also, again, an argument that's saying not having a license is not equal to exclusion. And even if the patent owner decides to sue component manufacturers for infringement, well, he needs to prove infringement, validity, and then he needs to obtain an injunction. And in the EU, we have Huawei versus ET framework that requires the SEP owner, before seeking injunctions, to offer a FRAND license. So it's impossible to exclude a component manufacturer from the market without first offering him a FRAND license. So in this way, we don't see how the indispensability requirement can be fulfilled in this case. So we speculate that maybe an abusive refusal to license would require an extreme set of facts, then the SEP owner would reserve the implementation of SEPs only for itself, prevents others from using the standard by massively suing for injunctions, not offering FRAND licenses, but that has never happened in practice, and for good reasons. That conduct would be also breach of a FRAND commitment. It would more certainly be a breach of competition law. So we don't see in the normal scenario, if the patent owner adopts a policy of licensing only downstream and doesn't pursue injunctions against component manufacturers, how can be their abusive refusal to license? Now, just briefly, and maybe we'll touch this later, some of you may know that in the US, there was a case, FTC versus Qualcomm, where Qualcomm was found to have infringed basically their abuse of dominant position in the US for refusing to license to competing chip manufacturers. And then in our paper, we discussed, well, can we, if we extrapolate the facts from that case and apply it under the EU competition law, would Qualcomm be equally found to have abused EU competition law? It's difficult to say because the EU has a different legal test, and under the EU legal test, as we saw, indispensability requirement would hardly be fulfilled. But also the Qualcomm is specific because it is also a chip manufacturer and also an SEP owner. So on the facts in the US, what was problematic is that chip manufacturer refused to license other competing chip manufacturers. So those principles in the US cannot be universally applicable to the whole SEP owners, because other SEP owners may be non-practicing entities which are not competing downstream. The other SEP owners may be also producers of end devices, and they're not competing with chip manufacturers. So the facts of the case cannot be universally applied. Next slide, please. And the final argument that we discussed is, well, there is a paragraph 285 in horizontal cooperation guidelines, which seems to imply that there is a duty to license to all. And the European Commission says, provides a guideline that in order to ensure effective access to the standard, IPR policy of standard development organizations should provide a commitment to offer FRAND licenses to all third parties. Well, does the reference to all third parties means each and every party, everybody who wants a license must be offered a license? Again, we are unsure that that's a correct interpretation, because throughout the horizontal cooperation guidelines, there is reference to the access to the standard and not to the imposition of the obligation to license to all. Even in the same paragraph 285, in the beginning, we have a reference in order to ensure effective access to the standard. And to other paragraphs, there was also reference that FRAND commitments should ensure access to the standard and so on. So, and as we have discussed, access to a standard doesn't need to be, is not only by a direct license. Access to a standard can be by non-assertion, can be by indirect license. So access does not equal only a direct license. Also, horizontal cooperation guidelines are only safe harbor. They are not, and they don't impose competition law obligation. And again, all third parties are not further defined. And as we have seen, SEPs have either claims that cover end devices, components, networks. And if the intention was really to impose an obligation to license to every company all along the production chain, it could have been said more clearer, just like IEEE IPR policy did. So we don't find a basis as it is formulated now that horizontal cooperation guidelines wanted to impose access to all, but we believe it talks about ensuring effective access to a standard. Next slide, please. So Jean-Sébastien, to conclude.
I think that by now the conclusion we have reached in our article is quite clear. The conclusion is that EU law, whether you take general principles of EU law, patent law, competition law, or contract law, which is actually also French law about ETSI, the law does not require LTE from SEP owners. In other words, the owners of standard essential patents do not have the obligation, even when they have taken a FRAND commitment, to license at all levels of the production chain. The only exception is if a specific SSO IPR policy expressly requires licensing at all levels. But as far as we know, only, well, today, only one SSO expressly imposes licensing at all levels. So in other words, what EU law requires is not license to all, it's access to the standard. And as has just been said, access to the standard can be achieved in various ways. Of course, having a direct license is a way to access the standard, but it's not the only one. You can also indirectly benefit from a license by selling components to an end device manufacturer who himself has a license. You can also conclude non-assertion agreements, or you can even use a patent without a license if the patent owner chooses not to monetize its patents or does not have a licensing program. Next slide, please. So if now we turn to the practical implications of our conclusion for SEP owners, well, what should they do? Well, of course, they should abide with the terms of the specific FRAND commitment which they have subscribed. So if they have subscribed the FRAND commitment by the IEEE, then of course, they should be ready to grant licenses to anybody along the production chain. But if they have subscribed the ETSI FRAND commitment, then they do not have to license at the component level. They're allowed to do so if they wish, but they are not bound legally to do so. The other conclusion would be that if SEP owners decide to monetize their patents, then they should adopt a licensing strategy and they should choose the level of the production chain at which they wish to license, because once they've chosen a level at which to license, then the patent exhaustion doctrine prevents licensing the same patents further downstream, while upstream manufacturers are protected by what we call have-made rights, because they manufacture, so to say, under the umbrella of the license of the end device. So these are our conclusions, and we can add that so far the empirical economic track record of various standards such as 2G, 3G, or 4G suggests that this mode of licensing delivers successful results. So the state of the law seems to us to be so far satisfactory. Thank you very much.
Thank you very much for the presentation. It has been very clear, and during the presentation we have received a lot of questions. So in the sake of fairness, I will take one by one by the order I received them. So the first one is, why rely so much on Huawei versus ETE in your doctrinal analysis, given the very specific facts of the case? I guess this question is for Nicolas.
Okay, thank you. So the Court of Justice speaks rarely about these issues, and Huawei ZTE is one of these rare judgments that we have, which discusses issues related to the nature, degree, and extent of obligation imposed by EU law in general and competition law in particular on SEP holders. And, you know, of course, you know, some people like to say, you know, Huawei was a very specific case related to a very particular context, but this, I think, is this entails or reflects a misunderstanding of the nature of the judgments in Huawei ZTE and the nature of the judgments that the court gives in proceedings like Huawei ZTE. So in Huawei ZTE, the court was asked a question of law, not of facts, by a national court, and the court had to interpret, in other words, read and explain the meaning of EU primary law. So the one-way ETSI case, of course, has a specific factual background which led to the initial dispute, which led to the question of law eventually, or the questions of law eventually. But it's a case in which, in fact, the setting in which one-way ETSI occurred is a particular procedural setting in which the facts matter less than the legal principles. And you know, it's the closest the court could come to an academic lecturing exercise. So that's why I think we rely on it, and we have confidence in the judgment, because we know that the judgment is less hostage to particular factual or circumstances and other judgments that you see, for instance, in you know, cases like, you know, Ringo, D-Link, or, you know, other cases which are really hardcore, like litigation, patent litigation disputes. I hope this helps. Okay, to be clear, that was the end of my answer.
Thank you. So if we accept, the next question is, if we accept that the SEP owner licenses only at end device level, are component manufacturers then exposed to infringement suit and uncertainty? I suppose this question is for Igor.
Yes. Well, that has been talked for quite a bit about, that component manufacturers are then exposed to infringement suit. But like we explained, if the SEP owner adopts a policy of licensing only downstream, then we don't see how it would then pursue successful injunctions against component manufacturers. And even if he does so, by the Huawei versus ETE, he must offer a FRAND license, and only for patents that do infringe. So we can't say that for sure necessarily the component manufacturers. I can hear some interferences, so I hope you heard me.
Yeah, we heard you. I have no idea where it is coming from, because everybody should be muted.
Okay. Next question.
So the next question is, does the contractual nature of the ETSI FRAND commitment mean that the relationship between an SEP holder and an implementer is contractual in nature, even before a license contract is entered into? Jean-Sébastien, should we use?
Yes, the answer is yes. As soon as a potential licensee expresses its interest for a license and, let's say, enters into negotiations with the SEP owner, then there will be a contract between those two parties under French law, or at least there will be a contractual relationship, because this relationship was born out of the right created by the ETSI FRAND commitment. But the difficult thing is that this contractual relation, while being contractual, is of course different from the contractual relationship which may eventually arise from the license once the license contract is concluded. So it could be called a pre-contractual relationship, but from the perspective of French law, it's already contractual. And so it's governed, for example, if there is a breach in the context of that relationship, it will be governed by the rules of contractual liability under French law and not by the rules of liability in tort.
Okay.
I hope this answers the question.
Yeah, thank you. Next one is, can you clarify the articulation between constitutional law and competition law? Question for Nicolas.
Okay. Yeah, so that's a good question too. So what's interesting is that in the Compton case law, so Huawei ZTE, and possibly in other cases related to IP and antitrust, the Court of Justice has a tendency to use and rely on principles and concepts that originate in other areas of its case law. And you know, some of these concepts are general principles of EU law. And so that's where, you know, with surprise, when you read the Huawei versus ZTE judgment, you stumble on this paragraph where the court talks of legitimate expectations. And it's interestingly, actually, the European Commission itself did that. I think it's in the Motorola decision. Back in the day, the European Commission used the concept of legitimate expectations. So we see the EU agencies and courts rely on general principles of EU law to reason their findings under the Compton prohibitions, and in particular Article 102. And so for, you know, there's many ways an agency or a court could reason an abuse of dominance case. It could reason the case on the basis of an establishment of anti-competitive effects, but it could also rely on more, say, moral grounds, such as a breach of human rights, or a breach of rights of defense, or a breach of, in this case, possibly legitimate expectations, right? And so it is tempting to read in Huawei ZTE a dispositive reference to a breach of legitimate expectations as the underlying reason for abuse. It is abusive because it breaches legitimate expectations, as much as it is abusive if the police officer gives you a ticket when you're the vehicle driver but not the owner, right? Whereas the policy said the owner will take the ticket. And so so the reason, the articulation between general principles of EU law and competition law is this. It's that the breach of a general norm of EU constitutional law might constitute the material reason why you find an abuse of the dominant position. And that's what we look at in the paper. And that's what we disqualify in the paper, because we believe that this principle of legitimate expectations has very little, it has a role, but it has very little, it doesn't have a role such as it would impose a requirement on patent owners to license to all.
Okay, thank you. The fifth question that we'll take is, what can the component manufacturer do if he is approached by the SEP owner to take a license? How can he check if the SEP owner has not already licensed the patents to downstream manufacturers? Could be a question for Igor.
Yes. Well, by the Huawei versus ZTE, so the SEP owner has to first offer a FRAND license and then to substantiate how did it come to the royalty calculation and how the component manufacturer is infringing. And as a part of the negotiation, I believe as a part of the Huawei versus ZTE requirement, after signing confidentiality agreement, parties should, SEP owner should disclose, well, who is licensed further downstream. And that's the way how to check whether the component manufacturers is protected by indirect license, by selling to a licensed downstream manufacturer. In that way, to prevent for double dipping, to licensing at the two levels of the production chain. I hope this clarifies.
Yeah, thank you. Next one is, does the ETSI FRAND requirement impose a most favored nation clause? For Jean-Sébastien.
I think that clearly the answer is no. Actually, if I remember well, at some point during the discussion about the preliminary discussion about the ETSI IPR policy, it was actually the introduction of a most favored nation clause was actually contemplated, but in the end it was not. It was rejected. So that alone suggests that there is no most favored nation clause. And besides, nothing, I think, in the wording of clause 6.1 of the ETSI IPR policy, nor in any other part of the ETSI IPR policy, suggests that there should be such a clause. So quite clearly, no, there is no most favored nation clause embedded in the ETSI IPR policy.
Okay. Next one is, in light of the Northern District Court of California's FTC versus Qualcomm judgment, could Qualcomm, under the same facts, be considered as abusing dominant position under EU competition law? It was more or less answered by Igor during the presentation, but you may want to add something about this. Nicolas or Igor, I don't know.
Yeah, I can take that question, and Igor might be interested in complementing. So, okay, so here I have to be a little, how would I say, a little, less academic and maybe a bit controversial, but I think we have to be realistic with that. So, there are in EU competition law two trends or two sets of views in relation to Article 102. One viewpoint is a viewpoint in which a dominant company has a special responsibility not to harm competition, and anything virtually which has minimal effects on competition constitutes an abuse of a dominant position. And this approach has been the approach vindicated by the legal service of the European Commission, not the entire European Commission, in courts, and we see in case after case, we see remnants of that old approach to abuse of dominant position. At the same time, and so that's the other stream of thought, there has been a tendency in the agency policy, but also in the court's case law, to introduce a more economically literate understanding of Article 102, and that involves more focus on assessment of anti-competitive effects and much less presumptive reasoning to the effect that a dominant company harms competition as soon as it moves a finger. And this, so the thing is, there none of these two streams of or sets of views as neatly prevails in the case law, unlike in the American courts, where the case law tends to be very clear and sometimes very ideological or very one-sided. So you can see the case law swinging from one state to the other, but it's all very clear. You may complain that it's too radical or ideological, but it's very clear. The case law of the Court of Justice is extremely difficult to decipher, and you can see here and there in cases elements of both mixing and combining. And so that ambiguity, of course, is to some extent a source of legal uncertainty for companies, implementers, patent owners, insofar as FRAND disputes are concerned, but it may be also a sort of discretion for the agency, which can really use, there's this saying in French, on ne sort de l'ambiguïté qu'à ses dépens. One gets out of ambiguity only at its own expenses. So agencies can be strategic in exploiting that ambiguity. So, if you look at the facts in so to come back to your question, if you look at the facts in FTC versus Qualcomm, you may say, given the existing ambiguity under Article 102, you could make a case of abuse of dominance because you could play and, manipulate and, find ways to invent a theory of liability which would lead to a finding of abuse. So, I would tend to say from the outset, if we play with what we have and the existing ambiguity, of course, and it's, there was this joke a few years ago on a blog, which said, what is a restriction of competition? And the answer that one reader gave was whatever DG Com decides, right? So, and that has been a bit the state of the Article 102 case. Now, I want to say that there is a source of optimism for people with interest in reason and logic and evidence-based policy, which is that the case law has sort of moved discreetly but incrementally towards a more economically literate application of Article 102. It's not a very clear evolution, but you can sense it, you know, with cases like Intel and so on and so forth. And it seems to me that cases like, you know, FTC versus Qualcomm road to the EU would today face a harder time that they might have faced maybe 10 years ago, because the court seems to be embarking in this journey towards a more reasoned application of Article 102. So on that, I want to say two more things. One is there is a tendency in the case law, you can sense it, to dislike Competition disputes, which are essentially revenue disputes discussions, revenue sharing discussions. And the facts in the case in FTC versus Qualcomm, it's pretty much a case about how the revenue is shared in across levels in the production chain. I think what competition authorities and what the court seems to use Article 102 for are cases in which the question is not so much distribution of revenue, but rather the exclusion of competitors, horizontal injury, but not the sort of sharing of the pie between two parties, one seller and one buyer. So that's one thing. So that might tell us, okay, the court would be very, very cautious before going to a finding of abuse under such facts. The second thing also is, and that's to some extent something that has not really been discussed in US law, but that might be discussed in EU law. I'm sorry, I'm being a little long, but you have to consider that a practice like Qualcomm's practice, which is no license, no chip, which was really one of the facts for which Qualcomm was found in violation of Section 2. When you think about that, you say, okay, that looks really bad, but you don't bring a knife to a gunfight. So if your main asset in the negotiation with important clients or potential clients is your chipset position, of course it's a big gun you're taking out of your pockets, but you need to also look at what the others have brought to the table. And in all these disputes, you need to really consider the bargaining position of parties on the other side of the table. And in fairness, I mean, if you look at the FRAND disputes, you're talking about mega disputes between gigantic organizations with very sophisticated legal advisors and phenomenal financial resources. And it's not too sure when you look at things from a certain distance that all the bargaining power lies in the hands of a company like Qualcomm. And so I think disputes of this kind should be looked at maybe more holistically by agencies and courts, and we should need to rethink a little when we face revenue distribution disputes in competition proceedings, because this is not what competition law is about.
Okay, thank you. Next one is, how would the principles of patent exhaustion and have made apply to suppliers of an SEP license if it is an off-the-shelf product not particularly designed for that licensee? Maybe for Jean-Sébastien or Igor?
I think it would rather be Igor, I think. But...
Yes, well, I'm thinking so of the shelf product, not specifically designed for the licensee, right?
Yeah, that's how will the principles of patent exhaustion and have made apply to suppliers of an SEP licensee if it is an off-the-shelf product not particularly designed for that licensee?
Not designed, but is it sold to the licensee? So I believe if that product, if a component is being sold to the licensed downstream manufacturer, it would be covered by the end device manufacturer's license. So whether it's made or was made, but I believe it's more important whether it is also sold to him, and when it's sold to him, it will be covered by the downstream license. I hope this answers, and the person who asked, if you could write a follow-up question, that would be great to discuss.
Okay. Another one is, it was directed for Nicolas. He says, you compared the ETSI IPR policy FRAND with IEEE's RAND policy, but what is your view of the various 3GPP IPR policies? The ARIB IPR policy says licenses must be made granted to, quote, anyone who uses an ARIB standards, end quote. The ATIS IPR policy, which was the subject of just cause decision in the FTC versus Qualcomm, says applicants, and TTC says all implementers. Only ETSI and TSDSI, which is the Indian SDO, have an explicit FRAND commitment. Can it be that different SDOs within 3GPP will be subject to different interpretations of LTA and ATA? And if so, will this not create an untenable discriminatory situation?
Yeah, okay. So that's a very good question. I like this question because it sort of suggests that there's a lot of complexity in the environments, and it is indeed the case. Now, remember that, and maybe the reading of the paper will clarify that this question of the difference between SDOs or SSOs patent policies is essentially relevant to the extent that we're discussing the principle of legitimate expectations, right? And so if we go for, if we believe that there is a need meet to the idea that you can abuse because you're breaching legitimate expectations, this only relates to the underlying assurances that come with the FRAND commitments, and they differ as much as there is heterogeneous patent policies with SDOs. So indeed, the application of the principle of legitimate expectations to SEP holders' behavior would create enormous complexity in the sense that one would need to look at the type of FRAND commitments in discussion to decide whether there is a breach of the law. At the same time, the upside is that there is some flexibility. It's not, full LCA or full ATA. But yeah, no, it's, I agree, it brings complexity. Now, maybe the principle, again, we said the principle of legitimate expectations, it's not the given that it can dispositively apply. It's very unclear. This reference might have sort of landed here in the judgment in ways which are more decorative than dispositive. We give, in the interest of being as unbiased as possible, we give as much strength as possible to the possibility that the principle might apply. And in the case it applies, and we say, it might be a stretch, but in the case it applies, it is very context dependent. It's SDO context dependent. Now, I think the next question is for policymakers to resolve. If they feel that this creates too much uncertainty, they can certainly adopt guidance or propose legislation to remove that uncertainty. And there's not only one way to do that, or one sense or one direction to do that.
Okay, thank you. At least there is something that is helping here to this question is the Article 55 of the 3GPP working procedures indicate that individual members declare to their respective organizational partners. So it means that the member is bound to the IPR policy of the respective organizational partner. So that should help clearly to answer this question. So moving on, the next question is, should competition law have more role to play? Can we use the exceptional circumstances from Huawei versus ETSI to impose a competition law duty to license to all? This question should be for Igor.
Yes, I think this relates to what Nicolas said about enforcement of competition law, and that abuse of dominant position is anything that the Commission says it is. So I think Nicolas answered this question by saying, well, generally abuse of licensing IP rights really can be just applied in exceptional circumstances. And from a policy perspective, and from everything we said, I don't think it's justified to stretch the exceptional circumstances even further.
Can I add something to that?
Yes, of course, yes.
Yeah, so, you know, as Igor says, I think, you know, one has to realize that, first of all, competition law is a set of prescriptive rules, not prescriptive rules. Competition law is not regulation, and I would resist any temptation to read in competition law the source of detailed prescriptive obligations. Second, you may say, okay, but you know, LTA or is not really prescriptive regulation. It's just to say, you know, you have to license everyone. But again, competition law operates on the competition law operates as an exceptional tool that corrects market failures based on the presumption that the markets, more generally than not, works efficiently, and competition law operates on the basis on the basic assumption that freedom to contract and freedom to invest work in ways which are efficient. And so the point that I want to make is we should not forget when we deal with these disputes that I think freedom to contract, freedom to transact, freedom to invent transactional mechanisms, freedom to deal is the rule. And neither the court nor the agencies have ever adopted principles which find to the contrary, which would say obligation to contract, obligation to transact, obligation to draft your contract in a certain way is a rule. This is not the way the tool competition law in modern free market economies is designed to operate. You know, the Court of Justice in McGill, IMS, Way, Volvo, Oscar Bronner, the US Supreme Court in Trinco said this very clearly. The rule is freedom to deal. The exception is competition liability.
Okay, now I think I have two questions for Jean-Sébastien. First one is, will it be discriminatory for an SEP owner to treat differently implementers at the same level of the production chain? If you want to take it, and then I will ask the second one.
Okay. Well, I think it's difficult to answer this question in the abstract because while it's clear that potential licensees at different levels of the production chain are not in the same position, manufacturers at the same level of the production chain may be in the same position, but it also could be that they are not actually in the same position because they could have different sizes. Some might be in a position to grant cross licenses, whereas the others are not. I don't know, the scope of the licenses they're seeking might be different. So I think it cannot be a general rule that manufacturers at the same level of the production chain are necessarily in the same position with respect to the non-discrimination prong of the FRAND requirement.
Thank you. And the follow-up is regarding the reasonable person's interpretation under French law. Does it matter in the interpretation that the parties' situation can change and therefore the interpretation of what a reasonable person will interpret. The telco industry is dramatically different now from when the ETSI agreement was made. So those that changed the interpretation?
Yeah, that's a very good question. Maybe I wasn't clear enough when I presented the slides. To interpret when the common intention of the parties cannot be ascertained. So you should look at the meaning which a reasonable person would have given to the terms of the contract at the time when the contract was adopted. That is not said explicitly by the French provision, which French Code Civil provision, which deals with interpretation, but that's an indisputed rule. So what matters is the interpretation of a reasonable person at the time of the adoption of the contract. So to answer more directly the question, the fact that the common practice may have changed in the industry since the time when the policy was adopted should not change the interpretation, because the interpretation is always based on the interpretation of the reasonable person at the time of the adoption of the policy. But then, of course, if a change in the common practice in the industry creates a discrepancy with the policy, the IPR policy, that might be a good reason to change the policy, but it's not a reason to change the interpretation of the policy.
Very good. So on these wise words, I will say maybe now it's time to close the Q&A and to conclude. As mentioned before, the recording and the presentation will be made available on the 4IP Council website. Also, please feel free to subscribe to our newsletter to receive updates on relevant academic studies, future webinars, and case law summaries. I would like to thank our great presenters and speakers of today. It has been really a pleasure to listen to you, and thank you for attending, to all the attendees to this webinar. Should you have any follow-up questions, feel free to send me an email, and I would like to wish you to stay safe and looking forward to welcoming you in the next webinar of 4IP Council. Thank you very much, Igor, Jean-Sébastien, and Nicolas.
Thank you.
Thank you.